Good evening. This is the September 25th, 2024 zoning board of appeals meeting down in Newcastle. We have some extensions tonight, Mr. Secretary.
The first one is Rakelin.
Is anybody here for the Rakeland extension?
She's on Zoom.
In the room or online?
Yes,
Oh, good.
sorry. Yes, hello. Amy Menace from Garrison Foundry for the zoning renewal for 20 Cary Lane.
And you're looking for
An extension, so we haven't started the project yet. We had some value engineering that happened, but we're hoping to be ready for our permit soon. The portion of the work that we met with last January on the garage is unchanged. We were expanding the house previously, and now it's just basically an interior renovation of the existing house and adding this third bay of the garage. So the portion of work hasn't changed from your perspective, and the rest of the work has gotten smaller, and it's really just an interior renovation of the existing house.
and how long do you think you need for your extension?
Well, we are hoping to start this fall, in a month or two, max. And then I wasn't sure how the extensions work. The project will probably take, 8 months or something to complete, 8 months plus. So, yeah, how does it work as far as?
Normally with a first extension, we're pretty generous. We usually give 6 months to start and a year to finish.
Oh, perfect.
If you think you can do the
that's fine.
project in that time, that's good.
Yes.
If you think you can't, let us know why and we'll consider it.
No, that would be ideal. So that gives us plenty of time to start and plenty of time to finish, and that would be great.
Any comments from the board on that? Anybody in the audience want to make a comment?
Just to be clear, 6-month extension or 6 months from,
Well, we'll give them a 6 months stay extension
okay, to the original,
well, that's not gonna work for them
that's all that, that's what I
because
was
they're gonna run out if they take 8 months to complete the project. So,
I see. 6
yeah,
months to
that's
start.
gonna be a problem. You say you can start in 3 months?
Yes, absolutely. That's
So
the
if you started in 3 months and you're gonna take 8 months to finish the project.
Yeah, sure.
Well, again, I personally like to be a little more lenient because you never know what's gonna happen. So we'll give you 3 months to start and a year from there to finish. So if you run over, you don't have to come back to us again.
Okay, and then we'll be like under construction at that point, and
Okay.
we'll have a better idea. I anticipate that we'll be done by then, but again, you never know. But that would be the plan, so that sounds great.
Good, okay. So I'll make a motion that we extend this application by 3 months with a year to finish.
I second the motion.
Chairman Giordino.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Great,
Okay.
You have your extension, good luck.
thank you very much.
Alan,
Yeah, it's Bill Spade, I'm here for Michael Allen, but Mr. Allen's also on the Zoom call.
So Bill, why do we need this extension?
We're still getting preparation work done for getting ready to do the work. There were a couple of things to finish up on the property in terms of existing permits that have taken time to finish up. So that's just about finished now. So what we'd like to do is get 6 months to start from now, and then 12 months to finish. We don't think we can finish the project within 6 months, so something longer in terms of the finishing would be preferable.
This is your second time at bat here,
Correct.
and there's not gonna be a third, is there?
It's not the intention at this point.
I know, it never is. again, I move toward the lenient side, and if you need 6 months to start and a year to finish, I'll make that motion.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Okay, you're all set.
Thank you very much.
You're welcome.
Have a good evening.
Barg?
Good evening, Mr. Chairman and members of the zoning board. I'm Jerry Garrett. I'm the landscape architect and planner for the project. And we are requesting an extension, I guess of 6 months and 12 months to finish the project. We are at a point now that since we were before you, maybe about 6 or 8 months ago, we have gone through and we've addressed all the town engineers' comments, all the town environmental coordinators' comments, and we're very close to satisfying all the building inspectors' comments. So we expect the building permit to be issued hopefully within a month or so. Hopefully, but everything's done, everything's queued up, everything's ready to go. It just took longer than we thought to get all these permits wrapped up.
Okay, so you're saying you're hoping to get all the paperwork done within a month. Tell me why you need 6 months to start then.
Well, because it's not clear, I gotta talk to the water department, apparently there's an RPZ backflow preventer on the house now, and it was put in by the irrigation company, however, the water department doesn't have evidence that there was a permit application for that, so it may have to be permitted in reverse. And it's unclear whether the irrigation contractor can permit that, or whether we've gotta go get a specialized engineer to do that. Because it has to get county approval as well as water department approval. We've done this before for other projects in town, and we've got a great guy who helps us with it, but I know it can take a little while to go through all those channels, if we have to go through the county and through the town.
I'm aware of that, you're right. So in that case, I'll make a motion that we grant 6-month extension with a year to finish.
Second the motion?
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Okay, you have your extension.
Thank you so much. Good night.
Good night.
When?
Anybody in the audience for when? Anybody online for when? Well, we can take this on our own, I'm sure, it's not a big deal. This is not a big project.
I actually think he's in attendees in the Zoom.
Is he
I don't
on
know
a
if we
Zoom?
can switch him over. He's under attendees instead of panelists.
Oh, can we get him on?
Let me see if I can help him back, maybe touch him in.
Hi, can you hear me?
Yes.
Okay,
Hi, can everyone hear me?
we can hear you.
Yes.
We can't see
Oh,
you.
okay, sorry about that. I hit the wrong button, I guess. Yeah, I'm Richard Bale, I'm the architect for the Wen project. So, yeah, we're hoping we could get a 6-month extension to start. We've been having difficulties actually finding a civil engineer for the SWIP that we're required to produce. And I think we're actually close to signing one on now, but we know it's still gonna be take some time because it's fairly involved to get the work done. So I was wondering if we could get 6 months to start and a year to complete.
Sounds reasonable, I know the paperwork can be daunting, we've run across this before.
Yeah, it's just hard to find people these days. And we're working more diligently to get one on board, but
Okay.
we're getting calls returned and that kind of thing.
Okay, I'm gonna make a motion that we give you 6 months to start and a year to finish.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Okay, you have your extension, thank you.
Thank you so much.
Okay, next up is Captain.
Please go up.
Evening.
Hi, can you state your name and the reason you're here for the record?
My name is Mitchell Cafton. I'm here have applied for a variance on an installation of a generator at my house.
14 Cedar Lane.
Excuse me?
14 Cedar Lane.
14 Cedar Lane.
And can you give us a little background on your need for a generator?
Because of power outages and which can be very frequent, especially when you don't have a generator. We had a really bad one winter where we had about 2 weeks of no power and about 20-degree weather in the house.
I've seen that. Okay, I'm looking at your site plan, and I noticed where your placement of the generator is. Is that near where your electrical line comes in?
It is, that's the reason for the variance is that my electrical devices are, where the generator would be, is, I guess, too close to the end of my property, for a normal installation. The variance we're applying for is because the next property next to ours is across Seven Bridges Road, so there's quite a bit of distance to the next property.
Yeah, I see, you're in a little corner here, that's interesting.
Yes, small, very small
And
property.
how are you gonna power this generator?
Propane.
Propane. Okay. And you have a tank already, or you putting a tank in?
We have the propane company ready to install when the permit is issued. I think they've already received the permit and the electrician has received the permit for the generator.
Okay. It doesn't look like a problem to me. Anybody on the board have a comment about this?
No, just again, just the reason that you're putting it next, you want to be near the electrical panel.
Exactly.
So, okay.
Anybody in the audience or online that would like to speak to this application? No. I'll move we close the public hearing.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Juan Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Would I like to make a motion?
Okay, this is an application to install a generator. It's 14 Cedar Lane. Basically, it's a front yard variance that's sought for the generator. The property is legally non-conforming. The required front yard setback is 60 feet. The proposed front yard setback is 29 feet, and the requested variance is 31 feet. I move that the variance be granted as requested. The granting of the variance will not create an undesirable change to the character of the neighborhood. The benefit sought really can't be achieved by some other method. This is a current problem within the community. It's becoming more and more of a fact of life. The requested variance is, not really substantial, and I think the placement of where the generator is has been explained. This really has to be near the electrical panel. The alleged difficulty, I mean, you could say it's self-created, but frankly, Mother Nature is causing this, so I don't really think that it's necessarily self-created in the traditional sense. And even if we were to find that factor is really outweighed by the benefit to the applicant, and there doesn't seem to be any opposition from the community. So with that, is there anything that the applicant needs to deliver to you?
A final survey, please.
Final survey, please. And with that, I move that the variance be granted.
6 months to start.
6 months to start, 6 months to finish. A year to finish. 6 months to start, 6 to finish?
Yeah, a year to finish.
6 months to start, a year to finish.
Okay, thank you
I
very
second the
much.
motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
That's it. Thank you.
You have your variance, thank you.
Lano?
Hello, I'm Thomas Lenarski, architect representing Charles and Melissa Lano for 130 Old Northbrook Road. If you could let Harlan,
Yep, he can go ahead.
okay, Harlan, if you could share your screen, please. Alright, the property at issue is a single-family residence on a 2.8 acre lot in an R2 zoning. And we are requesting a variance in the maximum allowable development coverage and a variance for the site setback requirement. The property previously had two separate variances on it, one to allow a winding driveway and another to allow the installation of a tennis court, which infringes on the site, the setbacks in the rear. So our project involves building a covered porch in the rear of the building and extending the paved patio there. We would do this in the style similar to the existing house. And we believe it's in keeping with the character of the house. The main reason we need a variance is that the tennis court that was put on the property in the 80s actually eats up a lot of the development coverage. And so the house itself actually, the property is using about 60% of its building coverage, but we're currently asking for a variance to the development coverage of 3,500 square feet or a bit more. Harold, if you could please show the site plan as well. You'll see that the patio extends into the side setback as well. We'll go out in a second. If you could zoom in please to the patio. So the new patio, our intention is to extend it over to the side, over the side setback.
Mr. Chairman, may I interrupt? That is not the application the building department received.
That was gonna be my question when he finished. I don't see anything on our denial letter about a setback variance.
Right, the patio that is proposed is within the legal right to
Exactly,
build, not
exactly.
in the side yard. We've only notified for a coverage variance tonight.
Right.
That will in fact increase the coverage variance if they chose to build that.
Right, yeah.
So I think we had
So what do we now, if they didn't notice for a setback, and you in fact need a setback variance, we have to go back to square one again.
That is correct.
But are they, is that in fact what's going on here? Because my paperwork shows nothing about a setback, only development.
That's what the building department has as well. This was a development coverage variance only at the time, according to the plans.
Right,
So there's been revised plans that we are not privy to.
okay.
If the applicant wishes to go forward, they will need to give revised plans and renotice.
Renotice it, exactly, yeah. You understand what's happening here?
I think so. We had, I think, the documents provided to the zoning board, I think, should all have been updated because this, as far as I'm aware, was submitted, this revised plan was submitted to the zoning board.
Our plans are dated August 5th that we're working off of, that your denial letter was created from.
Yes,
You know, there was no knowledge relayed to the building department that there was changes. So you have a right to go forward for the development coverage, but it will not permit the building of that patio.
okay, then I'd like to move forward with the development coverage. And I'll discuss with the client about the site setback.
You understand that you will have to, if you wanna build that patio, you'll have to ask for another variance separately for that development coverage.
I understand, we'll prepare to do that. I'd like to get the permission for the covered porch, if possible.
Mr. Chairman, is that all right with you?
I'm not sure we should go ahead with that. If that's not what the project is, we should not be granting or denying an application if it's not the true application. We need to know what the whole scope of the whole project is going to be. My suggestion is that you revise your application and come back to us. Now, do they have to renotice everything?
That is correct.
Yes. And then do they have to file a whole new application, fees and everything? Can we just amend this one?
It's just a renoticing fee.
Oh, okay. I think you'd be
So
better off
just-
doing that because
Just to clarify, I think what the issue is, we had filed for a building permit and revised the scope prior to presenting the application to the zoning board. So the documents that the zoning board has are accurate to the plan. I think the denial letter would need to be updated.
the denial letter is only with the coverage. And your notice is only with the coverage, so you have to renotice because we can't go forward without the proper notices. So you won't have to start from scratch, because you already got started with your coverage. We can't go forward with this tonight until you renotice and come back to us next time with the updated ask.
I see, so we would need a new denial letter from,
Right, you'll have to go back to the building department and revise your application request for the setback variance as well as the coverage variance, renotice it, and then come back to us and we will have updated paperwork at that time as well. And that we can then review the case and make a decision,
I see,
okay?
Okay.
So we'll see you next month.
alright, thank you.
Okay, you're welcome.
Steinbauer?
Mr. Napoli, how are you? State
Charles
your name and
Napoli.
why, the reason you're here, just for the record,
Say again, yeah.
even though we know who you are.
Yeah, you interrupted me, I was trying to do that. Charles Napoli, Chappaqua for the Stein Brothers, I am the architect. And we are seeking a front yard setback variance for a small addition to an existing kitchen that's located on Hamilton Drive. Very steep sides, very steep hill. The whole house was built very close to the road originally, well within the supposed setback, and we're playing around inside that setback by adding a couple of feet, 3 feet to the existing kitchen. You'll see on the site plan, I've colored it in as to what the addition is gonna be that is encroaching in the front yard, although it's nowhere as close as the rest of the buildings on the property, the garage and the existing house. It's a 3-foot addition to the side of what was a garage, then converted to a kitchen. We're just reconverting the kitchen and including a little bump out. On page 3, you'll see what it looked like. On page 4, you'll see the floor plan. And oh yeah, there it is. Thank you, Jackie.
Do you wanna
Yeah,
preserve?
that'd be great.
If you just keep your, do whatever you want.
So one. I just shot myself. There it is.
There you go. Come on, Jack.
Where's the
You know the
front-
right
and
answer.
where's the front sight of this?
There you go.
Yeah.
Move slow.
I can't see it.
You gotta,
Will you turn it around, Chuck?
Yeah, I think I had it.
there you go.
You can use this one.
It's coming.
You can use mine. This one's
This one's
working.
not working.
Here.
The trick one.
Shooting blanks. Alright. Yes. Here's the property line. It's Hamilton Drive. The 60-foot setback is back here somewhere. So the entire house is in the front yard setback. I'm adding this little bump right there onto what was a garage, which then was converted to a kitchen. We're just changing the kitchen, and we've added that little bump right there. And the setback, I think I'm asking for a 7-foot setback, which is less than what's already there, an existing setback.
So you're adding 3 feet, but you need a 7-foot variance?
It's a 60-foot, it's a 60-foot setback variance,
Okay.
and
You're at 53.
yeah. Yeah, the whole house is into the setback, so the 3 feet of the garage has nothing, is not the 7-foot. I'm not looking for a 7-foot garage addition.
Right, you need a 7-foot.
You can see how the front of the house right there, that is the existing front yard. I just it just clips across, pretty much stays the same as that was already there. But it's an addition, and it's in the front yard setback. The heights don't change, the mass doesn't change.
Right.
Then you can see on page 4 the roof line or the floor plan. Well, what I'm getting at is that there's no new
Right.
height, no impact to the front of the house, except makes it prettier.
Okay. Pretty simple to me. Anybody on the board have any comments? Okay. Anybody in the audience or online that would like to comment on this application? No. I'll make a motion that we close the public hearing.
I second the motion.
Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg. Warren Gottlieb.
Aye.
Kathleen Darazan.
Alright, I'll make a motion that the application of Adam Steinbauer for a 7-foot front yard variance to put an addition on their kitchen. Front required setback is 60 feet, they're proposing 53. This is a legal existing non-conforming structure where anything done to it would require a variance. This is a minimal addition to the home, but will provide the homeowner with much better use of their kitchen area. The granting of the variance will not create an undesirable change to the character of the neighborhood. There is really no other method other than seeking a variance that could achieve the desired end in this application. This is very minimal variance, percentage-wise, it's only 12%, foot-wise, it's only 7 feet. The granting of the variance will not create an adverse effect to the physical environment or the conditions in the neighborhood. This could be considered a self-created hardship, but given the fact that it's a legally existing non-conforming, I don't think that should be taken into consideration, and if it is taken into consideration, the benefit to the applicant will far outweigh any detriment to the town or the neighborhood. You'll need, couldn't have a foundation on this, right, Chuck? How you gonna,
Yes,
so we'll need a foundation survey prior to framing? And
why not?
well,
Yeah.
you could get special dispensation from our building inspector if you wanna go for it, but that's usually the case.
Please.
I'm waiting, I'm ready.
And we'll need a final survey upon completion, you'll have 6 months to start and 1 year to finish. You okay with that?
That's okay.
Very good. Any,
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
you have your variance, good luck.
Good to see you, thank you.
Take care.
Okay,
You're welcome.
next up is Jaguar Realty.
Hello, good evening, can you hear me okay?
Yep.
Great. I'm Henry Misas, I work with Tesla, I've been working on this project for a couple of years at this point, and thank you for the opportunity. We're here to request a parking variance from the required parking in the property down to what's needed to make this charging station forward. The required parking is 85 spaces, and we're requesting a reduction of 4 spaces, so down to 81 stalls. We've attended a few planning board meetings. The project has been reviewed extensively. We've done parking studies to support the findings. We've obtained approval from the planning board condition on getting the requested parking variance. So happy to explain anything regarding the proposed project. We can get into the charging station, how it works, or anything of that nature, but I would like to stop here and answer any questions or concerns.
So you're requesting to reduce the required parking from 85 spots to 81, correct?
Correct.
Just to make sure we get that right. And the charging stations will be, will take up, I don't understand why you're reducing it when you're just putting a charging station in. Are they wider than normal, that you have to take more property, or what's the reason for that?
Yes, there's a couple factors. Number one, we have to include one accessible stall, which is wider than normal. Second is that the existing stalls are 8.5 feet wide, which is a little too narrow for the use of a charging station. Just because it doesn't give you enough room to, if it's fully occupied, it's just better to have 9-foot wide stalls so that people can get inside, in between the cars to access the cable and use the charging station.
Okay.
I would say one more thing, we've iterated on the design to the point that the effective reduction, the number of stalls that we're using versus what's there, we're only reducing 2 stalls by what I just said, by incorporating an accessible stall and by widening the stalls from 8.5 to 9-foot wide stalls. The reason the variance requested is for 4 stalls is because the property is already underparked for reasons that we actually couldn't find out in speaking with the planning board, the planning director. If that makes sense.
So by underparked, you mean there's plenty of room there, so utilize it.
There is plenty of parking. Our parking study found that basically at all times there's vacant parking.
Okay. Any comments? Comment from the board?
No.
Is there anyone in the audience or online that would like to address this application? Someone with comment?
No hands are raised online.
Nobody online, okay. Okay with this?
What kind of variance are you looking, what is variance?
Just a,
Area variance?
alright, I'll make a motion, we close the public hearing.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Somebody wanna make a motion on this one? You wanna use
Using, I can do it.
No, you're gonna do it.
I make a motion that we grant a variance to Jaguar Realty at 238 Sawmill River Road for the reduction of parking spaces which has been vetted and reviewed by the planning board prior to our meeting. The reason for the reduction is that they need additional space for, I think you said, was it handicapped parking spaces?
Yeah.
Right,
And the charging places as well.
and charging stations. The granting of the variance will not create an undesirable change in the character of the neighborhood or detriment to nearby properties. The benefits sought by applicants I guess cannot be achieved by any other feasible method, since it's reducing spaces, so they're not really it would be different if they were adding. The requested variance is not substantial, given the nature of how many parking spaces there will be. It will not have an adverse effect or impact on the physical and environmental conditions of the neighborhood. There are no neighbors present or have written in opposition. It potentially is a self-created hardship, but it's understandable given the stipulations that they have to follow for governmental regulations. Tom, is there anything we need here for?
Just conformance with the planning board resolution.
Okay, and subject, the variance will be subject to conforming with a planning board resolution.
I'll second that.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
You have your variance, good luck.
Thank you, good night.
Temple Bethel.
Is that Temple Bethel?
I think they're on.
Oh, Bill Smith, I think. Are you there, Bill?
Her name is Emma. She is on the call.
What happened?
I do see her here.
She's on there?
She is on here, yeah.
Okay. How do we get her to get going?
I don't know. Yeah, but her screen isn't on either, so I can't either.
Should we come back?
Oh, she's coming.
Okay, there we go.
Alright, it was kind of frozen when I was trying to get in there. Hello, can everybody hear me okay?
Yes.
Can you tell us who you are, what you represent, and what you're here seeking for?
Sure. My name is Pamela Zakowski. I'm representing Infinity Solar Systems. And it's for the property at 220 South Bedford Road, which is Temple Bethel.
And what is that you seek?
We're seeking an amendment to a special use permit for the installation of a rooftop solar system.
I see there's memos from the building department and the fire department that there's some concerns about fire safety on the roof. Are you aware of that?
Yes, so part of the stipulations from the building department, they required us to meet with the Chappaqua and Newcastle fire chiefs. They also brought some of their coworkers. Their concern, specifically the Chappaqua fire chief, was that because of how the property has multiple levels, and they have a lot of like patios and permanent plant beds and things of that nature, that the fire department doesn't really have ladders tall enough to get to the roof in many parts of the building. They did go out one Sunday to check a few spots around the building with their ladders. And in addition to that, the Chappaqua Fire Chief says that his firefighters will not get on the roof in the event of a fire. He wants them basically to be on a ladder, leaning against the building with the hose without having them walk along the actual roof line.
And is that because of the solar panels or because of the roof itself?
That's the roof itself, that he just said that it's how the property is, the elevation and the size of the ladders that they have.
So I don't understand what the effect of putting the solar panels on the roof are going to have with fighting a fire if they don't wanna go on the roof anyway. Has that been explained to you?
I agree with you. So basically, when we were talking to the fire chief, we did agree to put a second disconnect on the property to make it easier if there ever was an emergency. The original plan set had one disconnect in the utility room. We did offer, and he agreed that we would put one, there's a Knox box to the right of the entrance. So we did agree to replace the smaller Knox box with a much larger one, so that they would be able to cut the power to the solar when they cut the power to the building. So a second disconnect.
That sounds reasonable, okay. Were there any other requirements that they asked you for?
He just mentioned that one specifically, making sure everything was labeled correctly.
Okay. Anybody on the board have any input on that?
No, good point.
Anybody in the audience or online that would like to address this application? No, okay. Got enough info, everybody?
Sorry?
Got enough info?
Yeah, all good.
I'll move, we close the public hearing.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Okay, I'm gonna make a motion that the application of Temple Bethel of Northern Westchester to have their special use permit amended to allow for the installation of, I just saw the number, 183 solar panels on the roof of their buildings, be approved for all those reasons. The Temple has consulted with the fire department with regard to safety in case there is a fire, but for the first responders to fight this fire. While they will not be able to get onto the roof, the solar panels do create a problem with electrical dangers. In order to alleviate that problem and hopefully solve it, the company Temple Bethel has agreed to install another disconnect near the Knox box, which will give them a much safer access to shutting the power off rather than going into a utility room if there's a fire in the building. Other than that, there is no other concerns about the installation. Installing the solar panels will be a benefit to the temple and also a benefit to our community and to the environment. Do we need to have any inspections or approvals before we go forward with approving this? Mike?
By nature, there's final inspections by the solar engineers before a CO is issued.
Okay, and the building department is involved in that as well?
Yes, sir.
Okay. So this will be subject to final inspection by the solar engineers and any approval needed by the building department. And we're gonna give you 6 months to start and a year to finish. Are you okay with that?
We intend to have it done before the new year,
Okay,
assuming the permits come through.
sounds good to me. Okay, I think we have it covered.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
You have your amendment, you're ready to go ahead. Good luck.
Thank you.
You're welcome.
Turkle?
state your name and what it is that you seek.
Good evening, Frank Bueno from Little Ridge Architectural Design in Nation of Colombo, Idaho.
I'm Lauren Turkell, I'm the homeowner.
We are seeking a variance to remove an existing non-compliant patio that's completely within a side yard setback and installing a new patio that is more conforming, which is only partially within the same side yard setback.
So the new patio will be less encroaching into the setback or the same, be less?
Less
So
encroaching.
you're reducing your
Degree of non-compliance.
encroachment. Okay, that's a plus. Board? Board on this end? Any questions? Anybody in the audience or online would like to address this application? No. It's, as far as I'm concerned, it's pretty simple and I don't have any lot of concerns with it. I'm gonna move we close the public hearing.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
I guess I can make a motion.
Go ahead.
I move that we grant a variance to Antonio Corvo and Lauren Turkell. They're removing a non-compliant patio and creating a new, more compliant patio above the residence, which obviously would make, we prefer more compliance, and this will improve their backyard use. This will be for the requested variance is 20 feet side yard variance. The granting of the variance will not create an undesirable change in the character of the neighborhood or detriment to nearby properties. The benefit sought by the applicants may be able to be achieved by other methods, but the fact that they're reducing their non-compliance is a good point. Requested area variance is somewhat substantial, but again, it's reducing their non-compliant situation current. It will not have an adverse effect or impact on the physical and environmental conditions in the neighborhood. There are no neighbors present or written in opposition to the variance. It is potentially a self-created hardship, but again, this is improvement of the use of their backyard and reducing the non-compliance. Tom, what do we need for this?
Survey, please.
Okay, we'll need a survey, and that would be 6 months to start, year to finish. Is that okay?
I'll second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
You have your variance, good luck.
Thank you.
Bow and Son.
Before we go forward with this application, in order to prevent any perceived conflict of interest, I'm going to recuse myself from it.
Really?
Yes.
Okay.
You don't agree?
I don't care whether, that makes you a no vote then, Tony.
No, I know we've had interactions in the past and I think it's only fair that I recuse myself for your benefit and mine as well.
So state your name and the reason why you're here.
Sure, my name is Whitney Singleton from the firm of Singleton, Davis and Singleton. I'm here on behalf of the applicants. They own a 6.1 acre lot in a 1 acre district. It is sufficient as to size and zoning compliant. Everything they're proposing to do is zoning compliant. And when they went for a building permit, the building inspector, as code enforcement officer, denied the permit based upon the fact that he said there's no longer a house there, therefore your non-conforming access is no longer valid. With all due respect to him, and he was very pleasant with me on the phone, that's an incorrect statement of law. What he said was because the house isn't there and hasn't been there for 21 years, that any non-conformities expire. The non-conformity that we're talking about here is the access that my clients achieve through an easement to their driveway. 280A of the town law entitles people to make application to access via an easement or a private road. It doesn't matter whether it's public road or private road. And this access has existed forever. It's been the only access that's ever existed. In order to access where they have frontage, over here, you have to go up a 50% grade, not 5%, 50%. It is very, very steep and it's very narrow, and it would be cost prohibitive to do, even if they could do it. We submitted an engineering report stating that it cannot be done compliant with town code requirements. The issue here is whether or not we're seeking a 288 variance to allow continued access to the premises the way it has always been, with an existing driveway, and existing water lines and everything else, or did that non-conforming condition expire? 288 is very clear that it is to be analyzed under area variance standards. Your board has determined on numerous occasions that access is an area variance, is an area criteria, it's spatial. Where I believe that the building inspector made a mistake is he was looking at the house itself, that it had been gone for 21 years. That's not the non-compliance. The pre-existing non-compliant feature of this property is the access. It's the driveway itself. That has never changed and has always been the same. So what we're seeking is a determination from your board overturning the building inspector's determination that the nonconformity is no longer pre-existing non-conforming, or in the alternative, a 288 variance. I believe very, very strongly that you rule that the building inspector determination was incorrect. And the reason I state this, and I set it forth in my memo, I think it would set a very, very dangerous precedent for your board. If every time somebody saw a building permit, they needed to get a 288 variance. If any other house on that road applies for a building permit under his analysis, he must deny it. So if you're gonna put up a shed, you're gonna put up a detached garage and an addition to your home, he's going to have to deny it under his analysis. I do not believe, that is not the law. The law is the access is pre-existing, even if it's non-conforming, it's pre-existing non-conforming. It is not being enlarged or in any way altered. We're not putting 3, 4, 5, 6 homes on that driveway. It is the existing driveway that has always been there. And based upon that reason, we're allowed to continue it. Your code says that if you have a pre-existing non-conforming condition, you don't even need to go to the zoning board of appeals to get a variance. And I cited that in my code. Alternatively, if you want to grant us a 288 variance, that is fine. I see that there was a memo submitted by the village engineer. I don't know whether you got that. Bob is not entirely incorrect in what he states in his memo, but his memo is a little bit of a red herring.
And do you have a copy of that menu?
Yes, I do.
You received a copy, okay.
Those issues have nothing to do with the issue before your board. To delve into that Pandora's box is simply exposing yourself to an area of review, not only that you shouldn't explore, but that you're not authorized to explore. The only issues under 280A that you are allowed to explore legally are issues of the suitability of the access. The water lines, the necessary water lines, fire access roads or anything else that he put in there are not for your board to consider. You're to consider one, whether we're a pre-existing non-conforming condition, and number two, whether or not you grant a 288 variance. Whether or not we need to make improvements to meet New York State Uniform Fire and Building Code have nothing to do with your board. If we need to make them, we will make them. But it is not exactly laid out, it's not exactly the way Bob has laid it out. There are many ways that you can meet fire codes, and if Bob were here, I'd ask him about it. But one, you can have turnoffs. You don't need to widen a common driveway to 20 feet. You can have turnoffs every 500 feet. 50 feet in length and 10 feet in width. When you have sprinkler systems in homes, that affects how you determine the fire access road, and it also affects the fire flow and pressure that's required under the New York State Code. These are not issues for your board. Those are issues administratively when we go to get our permit. The only issue before you is whether or not we're pre-existing non-conforming access, or alternatively, whether you would grant a 288 variance. Something else I wanted to mention. The heck was it? 288. Let me just check my note. Oh, I know what it was. Let me read it because I write it better than I read. I mean, I write better than I speak. Okay. The issues that Bob raises are red herrings, which a ZBA would be well advised to avoid entangling itself with. As Mr. Cioli is presumably aware, there are various ways to address or minimize both the fire access roads and water pressure flow requirements based upon different designs, which my client is planning on doing, that have nothing to do with the immediate application before your board. Provisions for sprinkler systems, water storage facilities, turnoffs, turnouts is what they're called. They all affect what the road design is and what the water supply is. We will deal with those. So I'm stating for the record that my clients will satisfy all applicable state building and fire code requirements under the Uniform Code. And I have no problem, and in fact encourage your board, that in drafting a resolution, that you incorporate such condition into any resolution you adopt. That is my application. I'm happy to answer questions.
Well, let me start off by saying I appreciate your passion. We have consulted with our counsel on this matter, and obviously you are correct in the respect that our purview is the right of way easement. But our counsel has a different opinion in terms of the requirements that we would want to put forth in a resolution in order to vote on this particular variance.
So you're regarding my application as a what about the interpretation that I'm requesting?
We're looking at it as a 280A.
Okay, is there any particular rationale why you wouldn't deem this as pre-existing non-conforming? Because it is going to burden your board in the future significantly.
And let me just say one other thing. I read through your entire note to many times, and so I have a good understanding of your point of view and I understand it. But Mike, do you wanna speak to that?
Yeah, we will, we haven't, we will review both aspects of the application. I've made a recommendation that we take the application under advisement, and given your memo and your comments tonight, and that we are gonna advise the board to take those conditions under advisement. We understand both the nature of the dual nature of your application, and we will we'll respond at a future board meeting.
Okay. at your next board meeting?
Well, if you can get it in time, if we can, I think we can have it done in time, can't we? Yeah,
And
okay,
I
yeah, next
mean,
board
my
meeting.
concern is, like a municipal council is, I don't wanna see your board say that when something is non-complying in any respect on a property, let's say your house is too close to the road, and it predates, it's pre-existing non-conforming. And all of a sudden, you wanna do something somewhere else on your property, the building inspector could come in and say, I'm sorry, your access is no longer suitable, your application is no longer suitable, you need to go get a variance for your house being too close to the road, even though you're building a shed.
You've made some very good points,
Okay.
and you totally have made very good points, and I can tell you that the board, we're neighbors to your prospective neighbors, and so we're not looking to rule over anyone unfairly. We just wanna do this the right way within our town,
Okay.
the laws of our
And
town.
I appreciate that, I have no problem with deliberation, I just really am very passionate
No,
about
you are
not
passionate, yes.
overburdening
No,
property
and
owners and
again,
applicants.
to your point, I really did read your note a number of times, and you made some very good points. So that's something that I think that we want to just take up with our council as well as the town members, and then just come back to you for the next meeting with a resolution.
Okay, and I just would like to really reiterate one more point. If whether we're pre-existing non-conforming or you grant a 280A variance, for our purposes, it doesn't matter that much. But either way, we will deal with New York State building and fire codes with regard to access and water and everything else. I just really don't think that that's germane to the issue before your board.
Duly noted.
Okay, thank you very much.
Thank you.
So we're adjourning the public hearing to a date certain?
We'll adjourn the public hearing to, can we say it will be to the next, to the October meeting?
Okay, terrific, thank you.
So I make a motion that we adjourn the meeting to the October zoning meeting, whatever date that, I don't know what that date is.
October 3rd.
October 30th? October 30th meeting.
Thank you very much. And thank you for reading the material carefully.
Thank you.
I second the motion.
Mike Nolan.
Aye.
I got all of them. Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan. Aye.
He's back. Our chairman is back.
Next.
Fishman, is it Fishman?
Yeah, Fishman.
Fishman.
Good evening. For the record, Corey Salomon from Zarin Steinmetz, here tonight on behalf of the applicants, the Fishmans that are here with me this evening.
Could you repeat your name again?
Corey Salomon.
Corey
Salomon from Zarin Steinmetz. So the property in question is 39 Barnes Lane. It's in the R1A zoning district. And a building permit application has been submitted for a single family home. It was denied for allegedly not meeting the minimum lot area. In the R1A zone, it's 1 acre, 43,560 square feet. So this lot, just a little history, was originally approved as part of a subdivision in 1982. At that time, it was 1.057 acres. 1984, there was an amended subdivision application that this lot was part of. The lot size was increased to 1.064 acres. Both subdivisions, they were approved by the planning board, filed with Westchester County Clerk. And before I get into the variance request itself, I just want to put something on the record, and I'm sure your board is aware and your council is. New York State Town Law 277 governs subdivisions in the state. 277(1) clearly states before approving a subdivision plat, the planning board shall require that the land shown on the plat is suitable for building purposes. 277(3) provides, and this section is entitled Compliance with Zoning. It provides where zoning ordinance or local law has been adopted by the town, which in this case it was, the lot shown on said plat shall at least comply with the requirements thereof, subject to the provisions of 278, which is the cluster provision, which is not applicable here. So in that case, the planning board had to have reviewed whether this lot was buildable and made that determination that it was. They also had to look at the zoning and make a determination that it was zoning compliant. So it's unclear to me why we don't think it's the minimum lot area, but that aside, we're here for the variance tonight. So the variance that we're speaking about is from section 421.5, which states any lot created by subdivision subsequent to the date of the zoning code was adopted, no part of such lot which is less than 1/2 the required width shall be counted as part of the minimum lot area. If you go to the final exhibit in my submission package, you will see that when you go into the lot from the rear where it's 75 feet, we have to remove a total of 3586.93 square feet, which leaves us at 42,741.965, which is 0.98 acres. So we're just 2% off of what's required. So the requested variance is a 2% variance from the minimum lot area. With that, more than happy to answer any questions you have.
Well, I don't understand why. The reason for your variance is because you don't have the required square footage.
The required lot area.
Lot area, because of a funny shape that the lot is.
Correct.
Do you know of any reason why the planning board didn't address this when they approved the subdivision?
I don't, and I have not seen those files. I believe your building inspector has reviewed the files and didn't find anything about it. He will speak for himself. I believe there was nothing in the file with respect to that. But again, 277 was, the law at the time in 1982.
Right.
So they had to take that into account.
I'm kind of leaning in that way too, I just trying to get some clarification on that. I don't understand why there's a problem here, because I would assume that the planning board was intended to create buildable lots when they approved the subdivision.
Correct, they have to by law, and in point of fact.
It's such a small percentage as well that it doesn't, to me, it doesn't seem to be a problem. I don't know how my board feels, and if anybody on the board has any input on that or would like to make a comment about it, let's do so and get it onto the record.
I have no comment.
No comments. Okay. Is there anybody in the room or online that would like to address this application? If so, please come forward.
Yes. We actually have,
Can you state your name?
my name is
and-
Dominic Petito, I live at 43 Barnes Lane, adjacent to this lot in question.
Good.
We actually have two other property owners here who would like to speak as well. Okay.
Go ahead.
We submitted an objection to requested variance. I don't wanna go through all the detail and bore everybody, you can read that.
We all read it.
You did, okay, good. I just wanted to state a couple of things. We don't believe this was a buildable lot to begin with. And I'm not a zoning lawyer, and you could do whatever research you want, but the building inspector clearly stated in his denial of the permit that this did not meet the minimum zoning requirements at the time the deed to the lot was recorded. So take that as it is. I'm sure Mr. DePaul did his research and made a determination that this was not a buildable lot. That was his determination in denying the permit. We also believe, while you may say it's de minimis, we think it would result in a substantial impact to the character of the neighborhood here. It's an oddly shaped lot, as you mentioned, on a very steep slope. The rest of the houses on that side of the street are completely set back. This would be much further in, where in fact from my house, I would see, in terms of the height of this building that they're looking at, I would see the top of this house, from my driveway, as I come down the driveway, as I come up the driveway, they're removing 70 trees, removes the entire sight line, and rather than being adjacent to us in parallel, it's way forward in terms of its positioning, and it's they've squeezed this lot in, and it doesn't fit in with the character of the rest of that development on that side. It was the smallest lot in that subdivision, and I don't know why they didn't put more area there, but the lot coverage from the building proposed, I mean, is way over similar properties on that side of the street. So we think that the variance, well, you may say is de minimis, would produce an undesirable change in the character of the neighborhood and will create a detriment to the nearby properties. And it's, well, at the minimus amount, 2%, the impact will be substantial, as noted in the objection that we filed with you. And it would have a significant and adverse impact on the physical and environmental conditions in the neighborhood. It's, again, as I mentioned, steep slope, the positioning of the lot, the direction of the lot, the way it faces, its height, its density, the coverage of the lot, the proximity to the street, and the position above the adjacent street, Barnes Terrace, in terms of runoff, it's gonna negatively impact all of the adjoining properties. And we don't know if this is self-created or not, but we detailed some of the history. The owners of this property had owned it, they had purchased the adjacent lot, they sold this property, repurchased it. They've been trying to sell this for 20-something years. I think they've had difficulty selling it. I think they had reason to believe from day one that this was not a buildable lot. And I think maybe I can't attribute motive or whatever, but I think they took a risk in buying a property that could possibly not be buildable. And we don't believe that a variance is appropriate in this situation. Questions?
Nope. Anybody else?
Hi, I'm Eric Post. I own 33 Barnes Lane with my wife, which is the property adjacent to the applicant's property immediately to the south. So you've all said that you read the objection letter and you've heard Mr. Petito, so I'm just gonna incorporate all of that without restating everything in the interest of time. Thank you all for your time tonight. Let me just say, this is not sort of what is probably the most typical application that you folks see, where someone's adding on a garage or bumping out a kitchen and adding on a deck and asking for a couple of feet in the community that they've lived in for 20 or 30 years. This is essentially out-of-state real estate investors who bought a property, sold it, bought it again, sold it, bought it again, and now are trying to sell it again. So when we talk, the reason why I mention that is not that that's a bad thing, but when we talk about the factors that this board has to consider, including the character of the neighborhood and the detriment to the nearby properties, you can believe a conclusory assertion from an attorney in a letter who says there's going to be no impact on the neighborhood, or you can believe the people who actually live there. These folks have never lived on Barnes Lane and they're never going to live on Barnes Lane, but we do. I can tell you, when I bought this house, I bought it because I loved the way it was so picturesque and sat up on a hill, far from the street, with lots of privacy. And if you look at the aerial view that's an exhibit to their application, you can see all the houses positioned on that side of the road are basically in a line more or less equidistant from the road, kind of sitting naturally the same way. It's beautiful. And this house is going to be wedged in between Mr. Petito's house and my house, as Mr. Petito said, way forward. So basically when I'm looking out my window, I'm seeing their back deck, and when they're sitting on their back deck, they're looking up at my window, sort of randomly, almost the way if you ever saw like a ski mountain and there's condominiums zigzagged haphazardly down the hill. That's what this is gonna look like. That's not the character of this street. That's not what the expectations of the street were when any of these homeowners bought it. And for that reason, I think that factor weighs highly in favor of denying the variance. The other factor I'll talk about, which is number 5, whether this is self-created. Again, they could have done due diligence when they bought it the first time. They bought it, they sold it, they made a profit, they decided to buy it again. And we don't know the whole history associated with that, but it seems that over this entire period, including the fact that the current buyer's contract is contingent upon getting a building permit, it seems somebody somewhere along the way knew that there is a problem. So with that, I incorporate the arguments that are set forth in the opposition letter and respectfully request that the board deny the variance. Thank you.
Thank you. Anybody else?
Good evening, I'm Bruce Weinreb, I live at 12 Barnes Terrace with my wife Andrea. We have lived there for over 39 years. Barnes Terrace is a lowest, I believe I was told at one time, the lowest lying residential street in Chappaqua. It is the same height as the pump station, so it is very environmentally sensitive. I believe today it might now no longer be approved for building because it might be wetlands. So this area has been very sensitive. All the homeowners, the 6 houses on Barnes Terrace, have fought a continuous battle against flooding. My neighbor, right directly next to us, we have brought in hundreds of square yards, cubic yards of fill to keep our front lawns from turning into swamp. There's streams that come down into Barnes Terrace and around across Barnes Lane. So we're very sensitive. The area has flooded several times catastrophically, with people getting more than 3 feet of water in the basement. All the houses in this area have sump pumps. I have 3 running all the time. Not all the time, but I have 3 sump pumps. People, my neighbors have built berms. We have maintained the stream. We have increased the size of coverts, all in a never-ending battle because water seems to win. Which gets us to the point when the continuation of Barnes Lane was completed in 1997. We were very concerned about the hard surface of the road creating more runoff. It has. The homes currently situated on this continuation of Barnes Lane, the northern end, are set back. They did the best job they could making long curving driveways, having lots of natural area to seep up the water. I have photos here if you want, I could show you. This is, I don't know if you can see, but this is standing on the corner of Barnes Lane and Barnes Terrace. You can see there's over 10 feet of slope from the top where it meets Gedney Park to where it comes down to Barnes Lane. It is almost a spillway when it rains. The town required these homeowners to put in a drainage system. I think it might have been designed by Rube Goldberg, but I'm not completely sure because it sucks up the water coming down Barnes Lane, sends it into a wetland, which I have another photo of on Barnes Lane, and then it crosses from the north side of Barnes Terrace to the south side where it loops back around, almost meeting itself, and it just becomes a tremendous amount of water. The last example I will give you is in the most recent storm, which was the remnants of Hurricane Ida. Our cul-de-sac got over 3 feet of water in a flash flood. We were continuously looking. The water came down my driveway. I'm on the north side. I'm sorry, on the south side, with such velocity that it broke my garage door. When I removed the cars at the last minute, I was able to open the door to back my cars out, which would have been put underwater, and move them up, further up. When I was walking back down, the water coming from the southern side of Barnes Lane, which slopes down to the corner, the north side, and the house directly across were coming with such velocity that there was turbulence on the corner. And I was actually fearing for my well-being because I was being washed back towards my house. Now to get to the point of this house will be situated literally on that corner, just slightly north of where Barnes Lane meets Barnes Terrace. I have lots of photos, but the one I will show you, let me get it here, is this handsome fella here. I have no idea who he is, but it bears a striking resemblance. The purpose of that is I tried to make it as level as possible. That's the low point of the property. It was about a foot over my head, so it was at least 7 feet high. And it comes to to the edge of the property and fall straight off. Because of the size of the piece of land where the house will be situated, with ledge, a lot of stone ledge in there, which completely takes away absorbability, if that's a word, excuse me, and the removal of trees, we fear that this could be the final tipping point that makes Barnes Terrace, the homes, almost unsellable. Because it will continue, as we know, weather's getting, I'm not a meteorologist, but weather seems to be getting more severe. This area is already under tremendous stress. I think at a minimum, you have to come see it to appreciate what we're going through. We have no problems having new neighbors. When our new neighbors built the cul-de-sac up in there, they did a fine job. But I'm fearing for the property values. These little homes on Barnes Terrace, these are not large houses. People have their whole lives invested in these homes and some young families. And I seek to protect it. So I please ask you to review this situation from an environmental standpoint and come look at the property. Thank you for your time.
Thank you. Anybody else like to speak? Would you like to address some of those concerns?
Sure, a couple things. One, with respect to the house, it's fully zoning compliant, it meets all the setbacks, height, coverage requirements. With respect to the contingency in the contract, anyone who deals in this business knows that when you sell vacant land, it's always sold on a contingent basis, so that's not abnormal. My clients, while they do have a house in Florida, they do also have a house at 84 Campfire Road right around the corner, so that is where they had lived. The intent of holding this property for so long, it hasn't been for sale for 20 years, as was alleged. They were saving it for their children, hoping that maybe they would all live in the vicinity someday, and that didn't work out that way, hence why they're selling it now. And with respect to the stormwater runoff, that is an extremely valid concern. But between Mr. DePaul, Mr. Scioli, Dennis Noskin, they'll address that. Stormwater regs, we're not allowed to have any more stormwater flowing off our property after construction than is flowing off right now. So that's something that has to, be approved throughout the process, not the purview of your board, but there's very capable people in Newcastle to make sure that happens.
Yeah.
We have.
I just have one more comment.
Sure.
Hi, my name is Paula Petito. I live at 43 Barnes Lane, and I just want to say that when we moved into our house in 1998, Bob Carlson, who was a realtor at Holmes and Kennedy at the time, called me and said they would like to sell the property to you for, it was about $325,000. So it isn't that they were saving this for their children, they were hoping to make a profit. That's all I have to say.
And last comment, it's been,
If you're gonna, in the mic, please.
And it has been on the market.
it's been, the property has always been, it's been listed continuously over the last 25 years. So there's been for sale signs, there's been people looking at it. So they could argue that they intended to live there at one point or have it for their children. There's absolutely no evidence that they ever intended to build on this. They actually even owned the lot that Mr. Post had. So they were, to me, it seemed more like real estate speculation. When they repurchased this lot, they actually repurchased it for the same exact price that they sold it 4 years earlier. I've never heard that in Chappaqua, that 4 years later you buy it at the same price. Now, why did the gentleman who first bought it from them not make a profit, just get his money back? Did he find out it was not buildable? Is that what happened? Don't know the relationship, don't know what was entailed there. But it was kind of interesting that they completed the repurchase on January 31st, 1996, 3 weeks before the subdivision for the Kraus property on the rest of Barnes Lane where Mr. Post and where I live and about 4 other houses. They repurchased it 3 weeks before that subdivision was approved. And then after we buy it, we're approached within a year by a realtor, and the prior owner of Mr. Post's property was also approached, would you like to buy this piece of property? Basically because we were the most likely buyers of an unbuildable lot. More really buying it for defensive purposes, just in case someday, some year, maybe 3 decades later, someone was gonna get approved to build a house on that lot. So there was no intention ever, that we can tell, due to the multiple listings of this property, that they ever intend to live there or let their children live there. So,
Understood. Any other comments? Would you like,
whatever.
you like to address any of that?
I mean, one, it's not really in the purview of your board, it's all hearsay back and forth, and so I'm not gonna keep going with this discussion.
Ready to vote on this? Anybody else have anything to add or? I'm gonna move we close the public hearing.
I second the motion.
Chairman Giordina.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Okay, we've already closed the public hearing, I'm sorry about that. Okay, anybody wanna make a motion? I'm gonna stick with this one.
You are a motion maker.
I'm gonna make a motion on this application, the Fishman application. Prior to the motion, I wanna make a comment that we have read the objections that are sent to us by the neighbors. We have listened to their comments tonight. And it is the determination of the board, speaking for myself, and if my board members wanna add to that, they can, that they have a lot of what they feel to be valid objections, none of which are addressable by zoning. The zoning code does not care if somebody's selling or buying property or making money or not making money. The zoning board cares about the zoning law. The zoning law is specified as to what size property you can have, where you can place your building on that piece of property, and if there are any parts of the zoning law that you cannot comply with, you're entitled to request a variance. The variance may or may not be granted depending on conditions and the determination of this board. That being said, I'm gonna make a motion that the application, the Fishman application for a lot size variance of 818.035 square feet, which is a 2% variance, be granted for the following reasons. This subdivision was done years ago with the intent of having buildable lots included in the subdivision. There may or may not have been a mistake or omission by the planning board at the time to not seek a variance for this one lot that doesn't comply. We don't know that, there's no record to address that. Therefore, we have to assume, given the record and the procedures of our planning board, it is my impression that they intended to make this a buildable lot. Although they may have neglected to follow through on their intention. And if this had been brought to the zoning board at the time of the subdivision, I am sure that it would have been granted. We are only here correcting what I believe to be a mistake in the original subdivision. The granting of the variance is not substantial whatsoever, it's a mere 2%. The lot size is compliant with all zoning requirements, it's even bigger than necessary when you take all the square footage into account, similar to the surrounding lots. The proposed building will have to meet all building and zoning requirements other than the lot size, which I'm proposing to grant the variance to. As regard to the stormwater drainage and flow, that's part of our building department's purview. They will make sure that if and when a building is put on that piece of property, it will comply in all regards to that flow requirements and to that stormwater retention requirements. It seems to me that the proposed building will not encroach on the side, front or rear yards, therefore being almost totally zoning requirement, again, except for this mere 2% of the size. I can't think of any other reason to put forward on this other than the fact that it will be a buildable lot upon granting of the variance, and it will just be another house in the neighborhood, just like all the other houses. And for those reasons, I think we should grant.
I second the motion.
Chairman Giordino.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
You have your variance.
Thank you very much, appreciate it, have a great evening.
You're welcome.
Great, thanks for your time.
You're welcome.
Approval of
We have the approval of last month's minutes, I didn't have my, up to date here.
Why do you say that?
Okay, I make a motion that we adopt the July 31st meeting minutes.
I second the motion.
Chairman Giordino.
Aye.
Mike Nolan.
Aye.
Ron Genzeg.
Aye.
Warren Gottlieb.
Aye.
Kathleen Darazan.
Aye.
Chairman is in order, I move we adjourn.
I second the motion. Everybody else?